You mentioned from potential political pressures from the top of the pyramid. What do you mean by that?
Well, okay, under nature of the action, which is usually a factual summary of allegations in a complaint, I'll just read it to you because it's the best way to do it. And pardon me for reading, but I'm going to do it here because it's important. Paragraph number 1 says, this is a case where the Department of Elections and its officials were prevented from performing their mandatory statutory duties by political intervention of the governor and others due to intra-party Republican politics. Specifically, the law clearly provides that the State Board of Elections shall order the holding of a primary election in any county, city, or other district of the Commonwealth in which it is notified pursuant to the Virginia Code that a primary is intended to be held, which, of course, we've talked about just a little while ago, which was properly done. In the case of the Republican Party's nomination for state Senate, such notice is to come from the Republican chair of the Legislative District Committee for the Senate district at issue. That would be Dawn Jones. It is undisputed that at all relevant times, she was the Republican chairman of that Legislative District Committee. She's never been kicked off. The question is, when Suffolk dissolved, did she lose any power in her vote? That is to say, did she hold that percentage of the weighted vote in the Legislative District Committee? This allegation is amazing right here. Paragraph number 4, upon information and belief, on March 10th, 2023, the governor and the attorney general directly or through their representatives strong-armed defendants, and that would be the State Board of Elections and Susan Beals, the defendants, strong-armed the defendants into reversing course on Senate District 17 primary. They did so due to an intra-party dispute regarding the contested nominating contest, as some party members have challenged Ms. Jones' actions under the Republican Party's procedural rules. While this challenge is incorrect, the court and defendants need not and should not delve into such matters, as no one has disputed Ms. Jones' status as the designated Senate District 17 LDC chair. And it says number 5, as a result of this improper interference, defendants quietly issued another list of primaries on the evening of Friday, March 10th. This list removed the Republican primary for Senate District 17. And this is the concluding paragraph, which I'll read right now. Paragraph 6, Virginia's election statutes do not set up defendants as arbiters of intra-party politics or require them to determine whether a chair's notice is in keeping with the party rules. Instead, the law is clear. If defendants receive notice from the designated chair requesting a primary, defendants are obligated to conduct that primary under Virginia Code Section 24.2-517. In other words, this is a mandatory ministerial duty that the statute requires the defendants to perform. If a party is concerned about a chair providing such notice improperly, it is the party's responsibility to control its own chairs to assess and prevent such actions before they happen, instead of attempting to deputize defendants, that is the State Board of Elections, Susan Beals as commissioner, as post hoc enforcers of the political party's internal rules. Because the law clearly requires defendants to hold a primary for Senate District 17 and does not allow political party members to force defendants into intra-party disputes or set defendants up as arbiters of what decisions by party officials are authorized or not authorized, then what they're seeking is mandamus relief, injunctive relief, which is where the court makes a judgment. Was the law followed by the legislative district chair, not whether Suffolk was properly dissolved or not. So what they're asking for is to enjoin the State Board of Elections from carrying out this change and instead reinstate the primary for SD 17, Senate District 17.
Can I take a swing at it?
Sure.
Sounds like to me that what she's saying is, as long as I am the district chair, the law says I shall declare, which she did, or file, which she did, and then the law says you shall order a primary.
That's exactly right. And the U is the State Board of Elections, which is, remember,
so the word in there
a
is
governmental
shall.
agency, a political subdivision that is not bound by a Democrat or Republican rule. It's supposed to be an independent agency, although the governor picks the members of the State Board of Elections, and whoever's in power. If it's a Democrat, then there's a one-person majority for the Democrats. And the same for our local elections boards. And if there's a Republican who's in the governor's mansion, then it is tilted one in favor, as it is now, for the Republicans.
So if the RPV,
You did this last time.
yes, if they're trying to win this case, then they've got to show that Dawn Jones is no longer the chairman of that local districting committee,
Well,
and that her filing is invalid because she had no authority to do so.
so as a lawyer, let me tell you right now, the style of the case is Dawn Jones in her personal capacity as a voter and official capacity as the chairman of the LDC of 17 against the Virginia Department of Elections, the State Board of Elections, those are the defendants, and Susan Beal in her official capacity as commissioner of the Department of Elections. RPV is not a named party.
Got you.
They would have to intervene, just like the candidates would have to intervene, like Hermie or his opponent would have to intervene and say, we are suffering an injury under Supreme Court Rule 3:14, and therefore we should be allowed to intervene. And then you have to ask by motion leave of the court to intervene as a party plaintiff or party defendant asserting a claim or defense therein. And then that gives the other side a right to respond to that intervention. So,
But it's a very tight window to do that.
correct, because I'm sure this is going to be expedited because this has to be determined pretty quickly, and it's been assigned to a judge, I'm to understand, and you're going to have an expedited hearing before the end of the month, which means like in a week or two.
The most surprising thing, and I need to make sure that you, because I'm just listening to this as you reading it for the first time, you mentioned the governor and the attorney general in that something that you read.
And that's something, it's called a complaint. Yeah.
Okay.
No, but you mentioned the governor.
Yeah, it's
And the
mentioned
Attorney
in the
General.
complaint. Yes.
So is Dawn Jones alleging that potentially the governor or somebody in his office and or the attorney general or somebody in his office may have been a
Contributed to this.
From what I've read, and I've read the whole thing, this is what they're saying, that someone from the governor's office, and when we talk about the governor, we're talking about an individual, but also everybody that works for him
Mhm.
on the third floor of the Patrick Henry building.
Mhm.
So, or a member of the party, so that could be anybody, this allegation went to the State Board of Elections or to Commissioner Beals. And I am also to understand that a letter from the chairman of the Republican Party of Virginia, Rich Anderson, was sent, maybe 2 letters, was sent to the commissioner. The commissioner, Susan Beals, good Republican, good person, very fair, she was good in, I think, Chesterfield. She ran the Board of Elections there for the local county and did a very good job. And so she got pressure from someone or all of them to rescind an order, a lawful order, in her capacity as the commissioner.
which she should not, regardless of how this plays out, should not have been put in that position.
Correct. Yeah, it's got to be a horrible position for her to be put in. You know why you're there. You've been appointed by the chief executive of Virginia, and maybe they want something to be different, but that doesn't mean you just, collapse.
And Hermie, you're
Couch out to
saying that your opponent's social media and website is announcing that was rescinded, but you as an official candidate has received no official notice from her of any change.
They pulled down the certification on the State Board of Elections website. Like they put primary up on Thursday, pulled it down like Friday at 5:00, pulled primary down, put it back up with convention.
Right.
But as far as I know, and this has been 10 days, 2 weeks later, there's been no official call from the LDC for convention sent to the State Board of Elections that I'm aware of. And to your second point, my opponent has posted the details of this alleged convention that apparently has not been made a call to the State Board of Elections yet. She somehow knows the date, the time, the location, and I assume probably the rules and everything else. And my campaign, we have not so much as received an official notice that the primary was pulled down. We have no explanation made to my campaign why it was taken down. And we certainly have no direct information on this alleged convention. And you would think that we would be getting the information the same time as the other candidate.
So that's why
I think you're deserving of it.
that's why the episode is called Shenanigans, because it stinks.